Hello, everyone, and welcome back to episode 14 of our association leadership series. My name is James Donnelly, founder and CEO of the Castle Group, and I'm joined again today by the great Donna Berger of the Becker Law Firm. Donna, hello.
Hello, great to be here.
We're really getting some great feedback on this series, and I want to particularly comment on the survey results from the last one, Donna. They really enjoyed, our audience really enjoyed the question and answer kind of open forum. So for our audience, we are going to go back to that. It sounds like you love being able to chat your questions in live and us trying to tackle them. But today we're going to turn to the legislature in Florida. The legislative session ends on Friday, and a lot of the bills that are impacting community associations have been debated, and we have a pretty good idea where they're going to land. And I also know I have some Texas listeners. The legislature, they only meet every 2 years out there. That doesn't end till May 31, so there's not going to be a lot of updates. We'll probably do a separate session on that. I want to remind everybody that if you have any questions or want to see past episodes, you can go to castlegroup.com or email info@castlegroup.com and on that COVID page, we still have all the information on vaccination sites and whatnot, COVID updates. So we welcome you to do that. I also want to say that Donna, as always, is very generous with her thoughts, but I want everyone to understand she's not giving non-clients legal advice here. So a little important disclaimer.
Although for my clients who are listening, hi.
That's right. They are getting some free legal advice, Donna.
Yeah, that they are.
So we also have some polling questions coming up, and I wanted to. The polling questions are of two types. One is related to the topic that we're talking about this day or at each episode. The other is we thought you, as our audience, would be interested in what your other community neighbors and peers are doing. So some of the questions are really just to share with you. Like there's a question today about how many are on your board, and do you have staggered terms? And that's not really specifically related to the legislation, although there is some clarification, Donna, about the 8-year limits and when it starts. That's in that omnibus bill. But more importantly, we thought you would be interested in what your peers across the state are doing. So today we're going to do a quick COVID update, a quick vaccination update, and then jump right into the legislative update. And but I did want to get out poll question 1 right away, Ness, so that we can find out what's happening out there with our communities and whether they're making any changes to their COVID policies. So Donna, this will be interesting.
Yeah, can't wait to see.
And while they're answering that, just quick update. It's interesting. Florida's still getting about 5,000 cases a day. It seems very stubborn at that number. Texas is actually doing better, Donna, 3,000 a day, and it's been very steady at that number. But you know, these new variants are coming at us, and my concern, Donna, is the vaccinations won't get here fast enough to stop this virus from mutating. But I can tell you that the vaccination rates in Texas, it's 48% of the population have got at least one shot, and 42% in Florida. So we certainly are getting there.
We are. Listen, the science is evolving. I mean, you turn on the TV at any given time and we're getting some new information. So it's like everything we've experienced the last year. We're kind of learning as we go.
Yeah, and Ness, share the results of the survey. It's probably not surprising, but Donna, you're going to have some comments today on being careful, even with this COVID liability bill being passed, on what we do. So it looks like it looks like one has increased restriction, and that's probably just someone who's had an incident, quite a bit decreasing, and a lot no change. So there you go, audience. That's what your peer group are doing.
So James, yesterday the governor did extend the statewide state of emergency for another 60 days until June 27. I think that's significant, and I think that's going to kind of frame our discussion, not only of COVID protocols, but of the legislation we're going to discuss.
Yeah, it's interesting. It's interesting messaging out of Tallahassee, and I guess I'm not sure whether they did extend it or not in Texas. But on the one hand, extended the emergency order. On the other hand, no vaccine passports. So it'll be really.
And you know, I think I do have an explanation for that, although I don't want to pretend to be inside the governor's head. But again, by virtue of extending the statewide state of emergency, that means it's not business as usual in Florida. There's something going on in Florida that is so significant that our governor has declared a state of emergency yet again. And this is the same governor who really does want and was one of the first to push to open businesses, to stimulate the economy. So you can look at it as mixed messaging, but what I look at is the more important message is the fact that that state of emergency continues to remain in effect until late June.
Yeah, and his language in that bill or in the executive order really was indicating he's not going to extend it again. Like his language was quite revealing, I thought. So I know, Donna, you and I have been saying this for a few months now, but I actually believe that June may be the last time. And that's going to be important for our boards of directors to process that. The other thing I want to bring up on the kind of the update side is, I think I mentioned it last month, is the unemployment insurance pay rate right now is so high. It's actually higher than a lot of the under $20 wages in Florida. It's causing a terrible challenge, especially in the hospitality industry and in the property management industry, just to get people to work. And I say that especially, obviously it's a property management problem in our world, but we have a lot of self-managed communities on here, Donna. I just want to share with them that I know they're feeling the pain, but it's across our industry. We're having real challenging time.
It's across several industries. Did you see the news reports on the new robotic wait staff in certain restaurants?
Yeah. Is
that something Castle considers some robotic, I don't know, staff members at some point?
Well, I think not. I'm all for employing humans, but you never know. So, okay, on the, I want to put out poll question 2, Ness and Donna. I was curious to see whether one of the adjustments our communities have made is to go back to in-person meetings. And so that's what we have up on the board right now.
James, can I just jump in here? So I had a client the other day. They wanted to have an in-person meeting. They were looking at about 50 to 60 people. It was going to be outdoors. I couldn't attend because I'm recovering from ankle surgery, which I have conveniently scheduled around these webinars for you. But I had an associate and, asked her, did you feel comfortable going? This particular associate has not yet been vaccinated. Her number hasn't yet come up. So in fact, we sent another attorney, but I think it's worth mentioning that when you're, having these in-person gatherings, you still need to look at the local orders, because some of the local orders do require a special outdoor event request be approved in advance of holding that event, and whether or not certain types of association meetings fall within the ordinary course of a business, or they would be something that the county would look at as being a special event that you could just as easily have done virtually. And if you're going to do it in person, you should reach out and get the proper approval. It is something to talk to council about.
Excellent. Let's share those results, Ness. It looks like that people are starting to return. Donna, I just think the option of Zoom is going to increase participation. I mean, obviously it's up to each individual board of directors, but if they're set up to have a Zoom option, I could see them really expanding their reach of participation by keeping a hybrid. I do think
absolutely. But remember, we're still under a state of emergency until the end of June. So it's not business as usual. I think you need to take that into account when you're holding these meetings. If your meeting looks like the meetings you had in 2019, I think that's a problem. Because your meeting in 2019
Well, Donna is frozen there right now. We'll see if we can get her back. I do have some questions on the board about requiring vaccinations and requiring proof of vaccinations. And maybe you guys can text Donna to see if these can reboot. I'll bring it up again when Donna's back on, but clearly the governor has given us direction that we're not allowed to ask for vaccinations. And there are some privacy issues that maybe Donna can speak to when she comes back on. But I think the general guidance is no, we at this point are probably taking on some risk for our association if we do look at those. So I hope that answered that question. Donna, are you back?
It looks like I'm back. Can you hear me?
I can, yeah.
Oh, okay, good. That's never happened to us before.
I know, we had a good run there without, but you know what we tell our audience, just log off and log back on. You did it.
Yep.
Don, I was just mentioning in your absence that we had a couple of questions on the board about requiring vaccinations and in addition with privacy concerns about, asking for vaccinations. And my general comment, my non-legal comment was, that the governor's been quite directional that he's not going to allow for vaccination requirements. Can you speak to the risks maybe an association would expose itself to possibly if it did demand proof of vaccination?
Well, I think you've got a problem with proof of vaccination as it pertains to owners in the community, because particularly with regard to condominium owners, those folks have a pro rata ownership interest in the common elements. Okay, so by shutting them down completely and tying it to proof of vaccination, I think you're setting yourself up for a legal challenge. There's also some back and forth and considerable debate, James, about whether or not the governor's order which prohibited proof of vaccine passports, whether or not that's going to apply to private residential communities. Are those communities business entities? Are there corporations? There's a lot of back and forth, but I think there's a colorable argument to be made that it does apply to an association, and you're going to further set yourself up for a legal challenge with these vaccination requirements. Now, if you knew in a small community that everybody was fully vaccinated and you've got proof of it and you're not mandating it, but people are volunteering it, then you may be able to change a lot of your operations based on recent CDC guidelines about the fully vaccinated and how they can traverse not only indoor areas, but outdoor areas. So that would be something to discuss. Look, I think in a community, if you could get everybody fully vaccinated voluntarily, I think it's going to help you really open things up and get back to normal. But in terms of requiring it, I think you're setting yourself up for a legal challenge.
Yeah, Howard is making a comment. There's a prominent hotel in South Florida that is requiring proof of vaccination or negative test within 72 hours in advance of arrival. They must obviously have some legal advice. It'll be interesting to see that, although based on what you just said, I would not recommend that for our communities. Which leads me I want to jump into some of the legislative bills that have passed. And before I do that, I do want to, Ness, put up poll question 3. I'm very curious to see how our audience are tracking what laws are changing. And Donna, while our audience is answering that, another question came in. It may be that we can't ask our residents for proof of vaccination, but does the same apply to asking a guest if they're vaccinated?
No, listen, I think let's start with the easy folks, vendors. So a lot of associations I've been speaking to, they want to do business with a contractor and make sure that the crew is fully vaccinated, or if the crew is not, that that they're still enforcing social distancing and facial covering. So I think when vendors are probably your low-hanging fruit when it comes to that. Other residents, you could, but now you got to look at what kind of visitors. What kind of visitor is this? If it's an immediate family member, are we going to tell that immediate family member, no, you can't come visit grandma because you're not vaccinated? again, I think you've got legal issues. And again, remember that there are people who may not be able to be vaccinated for religious or health reasons. And there's federal laws that protect those folks. And so you really do need to map out a reasonable policy when it comes to vaccination. And again, I don't think opening up is going to hinge on that for our communities. I think a lot's going to open up in terms of the protocols. And once we've reached herd immunity, and for all intents and purposes, we're told that, we're pretty safe.
Ness, share the results, please, of question 3. Donna, here's some good news for you attorneys, because a good portion here looking to you guys for their legislative update. I'm surprised they didn't all say, well, we log into James and Donna's webinar, but I didn't put that as an option.
That falls under other.
It does show you, though, how... Donna, it does show you how committed our audience is to serve. Look at that, 63% are taking their personal time to track laws in Tallahassee that affect their community.
Yeah, but let's touch on that really quickly, because I know we've got a lot of bills. It's to their benefit to track this. We are tracking at CALL, which is our Community Association Leadership Lobby at Becker, more than 24 bills. We're going to talk about 10 bills today. And one of those bills is going to have tremendous operational impact on our associations. By the way, all types of associations, condos, co-ops, and HOAs. So it's great that people are doing that, but it's important that they do that, because there will be changes. And if you don't follow those changes after the effective date of some of these laws, you could wind up in trouble.
Okay, so let's jump into the bills that we have. I want to start with Senate Bill 72, which it was passed last month. And it's the one that limits liability for all organizations, but specifically associations. Donna, can you just, I think the big question on our board's minds right now are, what can I do and can't I do? What will get me in trouble? Am I allowed to reduce restrictions in my community? Am I allowed to say no mass? And to me, this goes right to the core of Senate Bill 72. So where can our communities look to for guidance on what are reasonable measures?
So first, let me say that Senate Bill 72 is a step in the right direction in terms of the legislature recognizing the issues here and providing some comfort level for associations who are struggling to do the right thing, to safeguard them from those frivolous claims that we've been warning against for the entire past year. So Senate Bill 72 is the COVID liability bill, and it protects condos and cooperatives and homeowners associations under the category of business entities from COVID-19 claims for damages, injury, or death. It has a 1-year statute of limitation, which is also good news. But it's not a get out of jail free card, okay? In order to be protected, associations will need to prove substantial compliance with government issued health standards. So let that sink in. You've got to prove substantial compliance with government issued health standards. Now, they do make it difficult for a plaintiff to bring these claims. They're going to need an affidavit signed by a Florida licensed doctor about the COVID-19 infection. Although I will tell you, we've probably got people listening and said, well, with ESAs and service animals, somehow people managed to find Florida licensed doctors to write all sorts of things. I hope they're not going to do that in this case. But for our associations listening, you have to prove substantial compliance with government issued health standards. That's a little bit different than looking at the executive order that the state, Governor DeSantis's orders, he's not giving those orders on the basis of government issued health standards. We need to look to the Florida Department of Health for that. We need to look to the CDC for that. CDC just recently issued guidelines about facial masks, facial coverings. They're still recommending it indoors. So in elevators, corridors, lobbies, inside clubhouses, card rooms, gyms, they're still recommending you wear masks unless you know everybody is fully vaccinated. And how would you know that in an average community? Unless you're a community of 5 homes and everybody told everybody and showed everybody their vaccination cards, you're not going to know that. So according to CDC guidelines, you are still going to need to wear masks, even if you yourself are fully vaccinated when you are indoors, unless you're only with other fully vaccinated people. So for our associations, they need to continue to enforce their facial coverings. They need to continue to enforce gatherings. You shouldn't have 100 people on the pool deck from all different households without masks and without social distancing.
I think this may be the biggest takeaway. I think we all were relieved to see this bill go through and potentially limit liability. But I think the big takeaway, Donna, today for our audience is we're still under emergency order. We still don't have a governmental body recommending anything but wearing masks and social distancing inside. So it would be hard to argue right now for a policy that said, as an example, no masks. And I don't think we can be more clear on that point. And I hope that's helpful, because I know our boards are getting incredible pressure, Donna, to relax their restrictions.
And you know what, whether to force people to vaccinate, which we both know has considerable legal pitfalls, why not say to a community, guys, if everybody shows proof of vaccination, we can implement different protocols indoors. You know, I imagine there will be some communities, and I imagine they will be the smaller communities, where that's the route where people are all going to go, yeah, we'd like to walk around in the lobby without a mask, as long as, if it's just us. So that might happen, where we find some communities where they have 100% vaccination voluntarily, and they're able to change some of their protocols as a result.
Donna, I want to now turn to a bit of rapid fire. There's a bunch of bills that you're tracking that are either going to die or they're passed and they're not that consequential. Because I really want to jump into Senate Bill 630 for the last half of our hour here. But I know you've got a list there. I think you may have started with 522, but maybe you can just go down and allow me, if I can, to jump in between each bill to see if I think a question should be answered for the audience. So,
absolutely. So let's start. Senate Bill 522, that was the preemption of restriction of vacation rentals. We've seen this bill before. This was the bill that was designed to say no local governments, and there can be no local restrictions that restrict or prohibit short-term rental activity. Only the state could do it. And there was always concern, James, that might prevent short-term rental restrictions in our communities. That bill has been what we call TP'd, or temporarily postponed. So it's not looking like it's going anywhere.
Well, especially they got 3 days or 2 days to pass it. And if it's been postponed, it's probably not getting passed.
It's probably not going to make it. We have Senate Bill 1638, which was that pilot fraud program you and I talked about, James. That went nowhere. That was a program that was really going to be a target pilot program starting with Miami-Dade and Monroe counties. It was born out of the feeling that there's an awful lot of fraud going on in our community associations that needs to be ferreted out. But that's, for right now, that went nowhere.
Yeah, I think probably appropriately, that was a bit of a reach.
Yeah, again, because we live in a very large state. It's a very geographically diverse state. And what is true down in Miami-Dade and Monroe is not necessarily true in Lee or Collier or Duval or anywhere else. So I think that our legislators need to take that into account sometime, that when you're trying to change state law, please be mindful of the fact that we have a very big state in 67 counties. And what's a problem in 1 or 2 counties is not necessarily, you may actually wind up creating problems in other counties trying to fix in some counties. Moving on, House Bill 1517 and Senate Bill 1966. These are bills regarding board eligibility, James. Basically, every year when it comes to election time, we kind of scramble and say who's eligible, who's not eligible based on whether or not they are delinquent. These bills are likely to pass, and they say a person is delinquent if they haven't made the payment when it's due under the due date specified under the documents. If the documents don't specify a due date, then it is the date by the first day when assessment period is due. Okay. Part of the problem with determining, and I'm sure you know more about this even than I do, is when you're trying to determine eligibility, what about that grace period? If it says it's due on the 1st, but late fees and interest don't start accruing until the 10th or the 15th, and they pay somewhere in between there, and by the time they have had to submit their notice of intent, they have not yet paid, are they delinquent? And therefore, are they not eligible? So that's always been an issue. And then the other thing those bills do is they do make it clear, James, that the annual budget must be adopted at least 14 days before the start of the fiscal year. And I know a lot of communities sometimes get this wrong. They are late with their budget. This bill also does specify that the prior year's budget will roll over until you've adopted a budget.
Well, that's an interesting question. We always get time pressured because we have so many communities with all different circumstances. But in a perfect world, we get a budget approved in October or even September, and it allows us to communicate, have the meetings, get the coupons out without any rush. And especially with a lot of overseas or out of state owners, I mean, that sometimes it takes a while to get a notification to them and payment back. So what happens if so for our audience, I can't emphasize enough, both from a legal and a management perspective, have your budget meeting early. You at least get the process started early. I would suggest you should have a budget approved no later than, the middle of November. But
definitely
what happens
gets early?
Yeah, what happens with this law if we don't get it approved within 14 days of the end of the fiscal year?
Well, the good news is that it says the current budget rolls over. The bad news is if you have anybody who's a little disgruntled in your community, does anybody out there have at least one unhappy person? It leaves the door, it leaves room for that person to file a complaint with the division saying we didn't have our budget out, prepared within 14 days of the fiscal year. It's another area for a board to mess up. So to your point, James, I think it's good. This bill does look at least primed to pass. And we've seen a trend recently where the division is handing out more fines these days, as opposed to in the past, they used to give us some warning letters. So again, this is why, and especially when we get into the omnibus bill, it's going to be so important that you work with your management professionals and attorneys to make the necessary operational changes.
Yeah, and I want to just also hit on the eligibility requirement. This is clarifying, but basically, if someone is more than a month or a quarter late, they're not going to be eligible. And if they are just late based on the other criteria you listed, they may or may not be. I think you mentioned grace period. We've had this issue several times. I think the bottom line is someone that's 1 month or 1 quarter isn't normally a chronic late payer. And there should probably be more latitude than less. But this bill does help clarify that a little bit. And it's also something, especially for our self-managed communities, we kind of have a department here that checks that, but you need to make sure that all applicants for the board are eligible before you send out all the notices.
And why not pass a resolution clarifying when assessments are due? And that makes it easy to determine whether or not a particular candidate is eligible. So any other questions on that, James?
I had one question come in when we talked about short-term rentals and rentals. If a community association has a no rental rule, can they change that, and how? Just briefly.
What do you mean? Can they change it?
Make it into a community that allows rentals.
Yeah, absolutely. I've had some communities change the other way. But here's what's interesting. Under 718.110.13, which is the grandfathering of rental rights, which we're going to talk about really quickly in another bill, it says any change in rental restrictions is only going to apply to new owners who take title and existing owners who vote yes. And I've always asked myself, would that also apply to a loosening of rental restrictions? We all know it was designed to say, hey, if you make it tough to rent, and I bought and this community didn't have any rental restrictions, and I don't vote or I vote no, it shouldn't apply to me. But what if it was the reverse? What if you did, just as you said, buy into a community with very strict rental restrictions, and then the condo decided, hey, you know what? let's loosen it up. Does 718, 110, 13 still apply? Because it says change in rental restrictions. So that that really hasn't been tested yet, but that's an interesting point.
Okay, I guess the answer though is you can change it, but you have to follow the process in your documents for changing such rules.
You have to follow. You're going to need to have an amendment to your documents and achieve the mandatory threshold.
Usually a very high threshold. Okay, keep going. What other bills do we need to get through?
Okay, really quick. House Bill 649 and Senate Bill 996. These will pass, and these allow an association to file a single joint petition before the Value Adjustment Board to appeal ad valorem taxes in the community. There are a lot of particularly new communities, James, where the valuations are off. A lot of times, the first bite at the apple by the Value Adjustment Board is not a correct assessment. So it is, over time, a lot of communities have been able to successfully reduce the ad valorem taxes on their units by appealing. These bills will allow the board to file that single joint petition. Now, owners who don't want to be involved have the right to opt out and get their own counsel. But I will just leave it at this. Why is it important to seek a readjustment? Because that means more money in the pockets of your owners. More money in the pockets of your owners means they're healthier financially, which means they'll be in a better position to pay your association assessments. It's pretty much that simple.
This bill allows a community to do a bulk application. Is that
just a single joint petition? Yeah.
Interesting option for our audience. Very interesting.
And there are attorneys that do that on contingency basis too. Okay, so let me move on. So House Bill 665 is the grandfathering of rental rights that I just touched on. So in 718, which is the Condominium Act, condos have had to contend with this grandfathering of rental rights, that anytime they want to tighten up their restrictions, they have some housekeeping to contend with, because when they get the vote, anybody who's a current owner who did not vote at all, who voted no, that amendment's not going to apply to them. Now, over time, it'll apply, because as people move out and new people move in, the amendment will apply. So this bill 665 and its counterpart 872, they would transport that language over to 720, which is the Homeowners Act. It would be effective July 1st. So I am recommending, if this bill passed, and we still don't know, it looks like it might, amend your documents before July 1st if you want to restrict leasing in your community. Because a lot of HOAs don't restrict leasing. They're single family homes. Do I really care if you lease it out? But you might. Now, I will tell you that there is one exemption under this bill, which says if an HOA wants to restrict short-term renting, in other words, they want to prohibit renting for fewer than 6 months or more than 3 times a year, that amendment will apply to everyone, and that's good news. Okay, so that's the one thing.
A question in here: if someone takes title of a property by a tax deed, do the restrictions still apply to them? And I'm assuming it doesn't matter how you get title; it's the same. Yeah,
it's the same. It doesn't matter how you get title. Now, here's a troublesome bill: Senate Bill 56 and House Bill 339. Those are going to make it. These bills do look like they are going to pass. And they are basically just going to slow down the ability of condos and cooperatives to proceed with collecting delinquent assessments, okay, and homeowners associations as well. First big change is in an HOA, James. If you want to file a notice of intent to lien and then to foreclose, you have to give 45 days each time. In a condo and co-op, it used to be 30. These bills will now increase that from 30 to 45 days. Okay, you may say it's 15 extra days. When you add it up, 15 extra days, anything you do that makes it harder or delays getting the delinquent assessments in does one thing: it increases the balance. And bigger balances are hard to collect than smaller balances. So that's a little troubling. The other thing that's interesting under these two bills is that, you may change how you notify people of their assessments, right? At Castle, I imagine sometimes we're going to email you, we're going to mail you a coupon, but maybe sometimes you want to go green and just email it, right? So under these bills, you could not change the method of delivery, let's say you were using mailed coupon books and then went to email, unless you first notified the owners 30 days US first class mail, and then the owners acknowledged receipt of that notice. And I believe this is done because some delinquent owners will say, I never got my assessment, I never got notice of the assessment. And I think that's why the bill sponsors put this language in. But this is going to be a huge operational change for our managers and our self-managed boards, that you can no longer just decide, okay, now we're going to handle delivery of assessment invoices this way. You're going to have to get acknowledgement and consent from the owners to make that change.
It's going to be really important for our self-managed communities. You know, what we do at all the management companies is we literally have a little powwow in June to say, okay, because almost all these laws change on July 1, and we update our systems. But a lot of this, if you're self-managed, you really need to get with your attorney and make sure by July 1 you've adjusted policies. Donna, did you have 1490 down there? There was a bill that wanted to allow communities to invest their reserves. I don't know whether it was going to go anywhere.
We were looking at that bill. I don't have it as my list is moving, so I think that bill was killed. There were a lot of things not to like about that bill in terms of, oh, you can put it in an investment vehicle. Might lose it all, but
yeah, I did not like that one.
I don't think a lot of people did. I've just got two more, James, really quick.
Oh, okay. I thought we were going to the omnibus. Go.
No, I'm going real quick. So there was a home-based business bill that some of our mutual clients have been concerned about. That was Senate Bill 2661 and House Bill 403. Like the short-term vacation rentals, it was a bill designed to say that local government cannot restrict or prevent people from running businesses out of their homes. Okay. And of course, that naturally got some of our communities concerned, like, well, wait a second, we don't allow commercial use of the unit. Couple different things. This bill will pass. So there may be some confusion out there when it does. Just know that the actual language says local government.
Yeah, we've lost Donna, but I know what she's going to say. This bill says that local government can't restrict home-based businesses, but you can't. Commercial usage. We lost you there, Donna. So, but it doesn't say that associations cannot. So it's really where Donna's going with this. The bill's likely going to pass, but it's not prohibiting us as associations from passing those laws. So we're going to do another poll question now, Ness. I'd like you to put up number 4. I thought our audience would be very interested in what their peers are doing in terms of the structure of their board. Donna, welcome back. I finished your thoughts on the home-based business. You were just about to say that local government cannot restrict, but I finished your sentence to say it did not include associations in that, and therefore we likely still have the ability to have whatever restrictions we have in our community. How did I do? Should I get my bar exam?
You just need a blonde wig and a bar license, and you're good to go. Comcast is going to get a strongly worded letter from me after this. I think we're having a connection issue here. One last bill really quick, 902, which is community association pools. It's another bill that our mutual clients may hear about. It only impacts pools serving associations with no more than 32 units or parcels. So for our smaller communities, they are going to be exempt from supervision under Chapter 514. It's just a good thing. It's less regulation for our smaller communities.
Okay. Ness, share the poll results with our audience. Interesting here, Donna. 62% have staggered terms. I like staggered terms. It really provides for continuity of leadership. And the number one size board is 5, almost half, which is a great size board, by the way, unless you have a really big community.
Well, you know, that's by statute too, James. So the statute says that if your documents don't have a finite figure, if it's got one of those swings, the ranges, that it's going to be 5 for the statute.
Yeah, I did not know that. I'm learning things here today too. Okay, are you ready yet for the omnibus bill?
I'm ready. That was everything.
Where do you want to start on that one?
So I thought we would go through some of the high points and just hit through it and do it like what we just did, James. I'll just run through. This is, by the way, for our people listening, this is a 101-page bill. If I have another connection problem, James, you've already proved you can just continue on without me and I'll pop back in. One of the first changes was about subrogation, that a condominium unit owner's policy could not contain subrogation rights against the association if the association's policy didn't have it. This was born out of all of those lawsuits that have been filed by Universal Property and Casualty Insurance Company. This is a company in Florida that anytime they have an insured who suffers a water leak in a multifamily building, they have turned around and sued the association for negligence, failure to maintain the common elements. The problem is there was no due diligence, there's been no independent investigation, and as a result, we've got this. Do I love that language? I absolutely don't love that language because let's be honest, there are times when an association, none of our clients, but an association could have been negligent in terms of maintaining the roof or the windows, and by removing the right to subrogate, I think you're doing a disservice in those instances.
So this is a good part of the bill. By the way, is 630 passed or is it going to pass?
Oh, 630 passed. So it's done. And now it's just, all the bills go to the governor, James, and then he's got 15 days to act on it. But we have no concern or fear that he's going to veto this. This will become law. Okay.
I just wanted to mention that this is called an omnibus bill. What they try and do is load everything that has to do with condos and HOAs and co-ops into one bill. And that's why it's so big. But what's the next point, Donna?
Next, just a couple of quick things. Bids for work to be performed must be maintained for at least 1 year after receipt of the bid. I think most of our people are doing that. In terms of document inspections, James, an association may not adopt rules requiring a member to demonstrate any purpose or state any reason for wanting to inspect the documents. I don't have any clients that have that in their rule. Do you?
No. I want to go back to something you said on the 1 year for bids. You have to keep bids for 1 year. I believe the statutes were silent and you had to keep them for longer. This is actually
from inception.
Yeah, from inception. So this is
correct. You are correct. Yes, that is true.
This is a really good thing for maintaining records.
So this has tightened it up a little bit, and it is. So let's go on. One huge one: transfer fees are going to be increased from $100 per applicant to $150 with a CPI, a consumer price index increase added in. That $100 per application has been in there for years and years. So many associations have had to come out of pocket because that doesn't cover the screening. It doesn't cover the background check. Remember, applications are considered, spouses are considered one applicant, parent, dependent, child are considered one applicant. I will only say with regard to this, James, that I have seen some associations be sued in class action lawsuits because they are charging too much. They're like, okay, well, we were charging a $100 application, but we're also charging a $75 background check. You can't do that, folks. You can only charge what the statute allows you to charge in connection with a transfer of a unit, which is a sale or a lease of a unit. So be sure you are not exceeding what you can do statutorily.
When we had the litigations, the class action lawsuits going through the industry, we actually did an audit of all our accounts just to make sure that they were all compliant. And there were several that weren't. But this provision was put in there because our communities were telling us that $100 doesn't even cover our costs. So this was an attempt at trying to help out the communities with a little more. And in terms of take-home value, there'd be no reason not to start immediately as soon as this is signed by the governor to increase that fee, Donna.
Yeah, absolutely. But guess what, folks? You could amend your documents to require the unit owner to conduct the background check and give it to and share it with the association. So that's another option in terms. I don't know that 150 is going to make them whole. I don't know what the screening companies are even charging now, but I think it's even more than 150.
Well, it often is. I would have had this number higher, but it is what it is. But does this apply to HOAs as well?
Yeah, this is going to apply, this application is going to apply to all of them. So let me just go through. Oh, this is an interesting one, James. Remember when contracts with a service provider that was owned or operated by a member of the board was prohibited, and then it went through the third degree of consanguinity? And so that's no longer the case. They're no longer prohibited. You can do business.
This is important. A board of directors can now contract with their own association. And it's funny, I have mixed feelings about this. On the one hand, it certainly sets things up for conflict and all of that. But on the other hand, you may have a 10 unit, HOA or condo, and everyone's pitching in, and it could be the best way to get stuff done. So I see both sides of this, but I'm not sure why they passed this. Do you have any background on it?
I don't. I have no insight into why. I don't have any insight into why it happened. So, they say you don't want to see the sausage being made, James.
Yeah.
I don't know if we want to see that. This is an interesting one. You cannot prohibit the installation of a natural gas fuel station in your community. I can only hope that you don't have somebody installing that next to the electric car charging station. Let's hope that hasn't happened. But that I do know that one of the sponsors, that's their industry, is natural gas.
If I understand this one, right now, if you wanted to put in a common element electric or natural gas charging facility, it could be deemed a material alteration and need a vote. This law would allow a community to put it in without a vote. Is that not true?
With the electric car station, it is no, as long as the person is putting it within their limited common element boundaries. Okay, so the current law, James, with regard to installing electric car charging stations, not a material alteration, and you have to allow it, but they can only install the car charging station within the boundaries of their limited common element parking space. They can't put it somewhere else, and they have to separately meter those electric charges. Now, the association, just like with satellite dishes, can install a community-wide car charging station. With this says it may not prohibit the installation of a natural gas fuel station, and the unit owners have to comply with all federal, state, and local laws.
Okay, what's next?
Let's see. So that went on for quite some time. Oh, this is an interesting one. So the parties in a condominium, when you had a dispute in a condominium in Florida or the cooperative, it went to the division for mandatory pre-suit arbitration, correct? Now, and for a long time, they talked about actually requiring HOAs. HOA's alternative dispute was a little bit different because you didn't go to arbitration, you went to mediation, mandatory pre-suit mediation in an HOA. So for a number of years, our legislators were toying with the idea of requiring HOAs to seek mandatory pre-suit arbitration. This bill does the opposite. This bill now says that parties in a condominium dispute can now choose either pre-suit mediation or arbitration through the division. I like that provision.
So they have to go to arbitration.
They have the choice now to say, I want to go to mediation. Now, why do I like that? Because we've seen somewhat more consistent results with mediation as opposed to arbitration. However, election and recall disputes, mediation will not be an option. Those still have to be arbitrated. However, you could also file those in court now. So it's interesting what they're doing with regard to alternative dispute resolution here. And this, I believe, was language that was floated by the Florida Bar.
Well, Donna, this is one where our audience just needs to ask their attorney, right? Like, yeah. you get
yeah, you're going to want to use the forum that makes the most sense for your particular dispute. And again, it has to comply now with what the law says, where you go with that particular dispute. Oh, here's one that was born out of my task force. Do you remember the task force, the Florida Bar Task Force on Emergency Powers? So I can't say we got everything on our wish list because we certainly did not. But what we did get is that the omnibus bill now does change the emergency powers language, James, in all three of the statutes to confirm and clarify that it does apply to a public health crisis or a contagion. which is wonderful. It allows, shutting down of access. It allows spending on enhanced cleaning protocols. You look like you wanted to ask a question.
Well, no, I just think this is important because we had these emergency powers as boards for, say, a hurricane, but all along came a pandemic and we didn't have any provision in law. So this adds contagion to those emergency powers.
It does, which is a great thing. But there's one disappointing thing in this section, is that because of the strong realtors lobby, they put language in that said, but in no event could a board, in the midst of an emergency, a public health crisis, or a contagion, shut out realtors and their guests from accessing the units and the common elements. For me personally, I think that's a bridge too far. And I'll tell you why. In the height of the pandemic, I think people were understandably concerned. And to say that you had to continue to allow open houses and continue to allow people to come in and out. And not only now, this bill not only says the units, but the common elements. So as we talked, James, people were loosening up their protocols throughout the crisis, right? As the months wore on, we went from maybe, okay, you're not going to do a virtual, you're not going to do an open house, but we're going to let you have one-on-one showings of the units. But in most cases, we didn't say, by the way, you can take them to the gym, you can take them to the pool. All of that stuff can be shown. They could be in a car and drive by and go, there's the pool and there's the tennis court, but they didn't have to get out. So this is troubling because this says it says you cannot restrict that. And as we saw last year, I think the realtors themselves would say it was one of the greatest years they've ever had in terms of real property sales. And much of it was done in the height of the pandemic virtually. It didn't seem to stop many people.
So bottom line is, we as boards can no longer restrict realtors from having open houses during these emergencies.
And not even just open houses, but they have to be allowed to go into traverse the common areas and the recreational amenities.
I know you're going down a list there, but one I know the audience is anxious is, there was some provision in this bill, was there not, about codifying the ability to have meetings by Zoom and other media?
Yes, that was part of the emergency powers, and thanks for bringing that up. Again, lesson learned during the pandemic, fortunately incorporated into this omnibus bill. So it does clarify that we can have virtual meetings.
Well, we did get, if you recall, when we thought emergency powers were going to end, we got a lot of questions from our boards about whether they could continue to do the Zoom type meetings, and we now have that in law. I think that's a good thing.
Yep.
Okay, so what else?
Is there anything else okay, let's move on to cooperatives. Cooperatives also has a board or committee member participating in a meeting via telephone, real-time video conferencing, or similar real-time electronic or video communications counts towards a quorum, and such member may vote as if physically present. Again, just what you were saying, James. A lot of the changes from here are just reiteration of what the changes were in the condominium portion. Again, we've got language in the cooperative statute that now says that you can't tell people who want to see the documents, well, what's your purpose for seeing the documents? And I think that's sometimes born out of the fact that some people who are asking to inspect documents may actually be conducting low-key discovery before going into litigation. But at the end of the day, it's the members' documents. So you have to, as long as you're following the statute and you're not disclosing privileged and confidential information, you're fine. The same emergency powers that we just discussed in 718 are also going to be set forth in 719. The petitioner in a recall dispute may choose to go either directly to court or to pursue arbitration with the division. That's a huge change in both 718 and 719. That if you want to seek a recall, now you can go directly to court. I don't know how many will, because court tends to be more expensive than arbitration, but it's in there.
And just there, because I know we don't have too many co-ops on the call because there aren't many, but 718 is condo, 719 is co-op, 720 is the HOAs. I saw a clarification in the 720, the HOAs about turnover. There was clarifying that turnover of an HOA will be triggered 3 months after 90% of the units had closed. I don't know what it was before, but that seems very specific. And I know.
And that was born out of the fact, James, that some developers build into their documents these tentacles where they can stay in control for a long, long time. There's a community in Plantation, I won't name the community, but the developer's been in there for more than 2 decades. And you can imagine the frustration that that creates amongst people living in the community who want to move on and start setting their own protocols and, charting their own course. So that's actually a welcome change, and I'm glad you raised that one. Some of the HOA changes, 2 years ago, I think it was 2 or 3 years ago, the definition of governing documents in an HOA were expanded to include rules and regulations. Now these changes remove that. Again, I believe that's born out of the Florida bar's language, and it's to clarify. In addition to authorized means of providing notice of a board meeting, the association may also adopt a rule for posting the meeting notice and agenda on a website. This adds or an application. I don't know, how many of your HOAs have developed apps, James?
Well, almost none of them have, but we have one, so they can use our app. And we actually supported this part of the legislation because most people are moving to their mobile device. They don't even go to the website anymore. But the way the law was written was you had to post on the website. So this really gives our communities more flexibility that they can use their phones and iPads, and they don't have to go to the website. So I think that's a good one.
Do you think that what we've just been through the past year has helped some of our communities overcome their reluctance to embrace technology?
Oh, absolutely. I think you're going to see electronic voting, and I know Becker has a great app for that. I think we're going to see, I've been waiting and thinking, when is this going to take hold? And I think this may be the trigger. The electronic meetings, the Zoom meetings are going to take hold, I think, permanently. So I think we're absolutely going to see some permanent change in how we run our communities. And for the most part, I think it's been good.
I agree, particularly for communities where you have a significant percentage of your owners who are out of state or international. It's just been, it's been kind of a godsend in terms of increasing participation.
It really has. Donna, we're 1 minute left, and I wanted to both put up question 5, Ness, and ask you at the same time, Donna. We've talked a lot about changes in law and changes of approach and whatnot. Is this not time? We've been through a contagion. We've even got Tallahassee changing laws. Isn't it time for us to revisit our own documents? You and I have talked about this for a year now, but we now have kind of gathered so many things. We could actually do a fairly comprehensive amendment rather than these one-off amendments, which are difficult to do. I think it's more efficient to just get all the things that we've learned into one amendment and try and get that passed. What are your thoughts?
Well, my thoughts are there's no more local restrictions than the restrictions in your governing documents. That is they say government impacts you the nearer it gets to you. There's nothing closer to people living in condos, co-ops, and homeowners associations than your set of governing documents. We know in Florida, and I presume it's very similar in Texas, even though they only meet 2 years, we meet 60 days each year, is that there's going to be changes. And as we've talked about today, this afternoon, some of these changes are significant. You cannot typically apply legislative changes retroactively, or it's considered unconstitutional as an unconstitutional impairment of contract. So that is why it's crucial to keep your documents updated, because you may have a change in the law, but it won't necessarily apply to you if you've already amended your documents. So it is important to keep it fresh.
Well, Ness, share that. I think you're having some impact here, Donna. Look at the percentage of people who are considering this. This is fantastic. I think this is having your documents support the mission of the community. Okay, Donna, as usual, even with your inconsistent Comcast connection, great job. Audience, thank you so much for jumping in. We will report back after July on what the governor's signed so we can be definitive on what's passed. But I think this will be very helpful and directional. Our next series event is May 12th with my partner, Craig. So please join him for that one, and we shall see you in a month. Donna, any final comments?
Two final comments. It's a pleasure as always. For our Becker clients, stay tuned for our legislative guidebook, which is going to go through all of this. And I just want to say, for those of you who have enjoyed James and I having this repartee for the last 13 months, turnaround is fair play. I have a podcast coming out called Take It to the Board, and my very first guest is going to be none other than James Donnelly, superb CEO of Castle Group and founder. So tune in. We'll broadcast that. But James is going to be on the other side answering my questions.
No, I'm a little scared of that, Donna, but we're going to tape that next week, and it should be out soon. So congratulations on that, having your own podcast. That's very interesting. Okay, everybody, have a great week and month, and good luck. Thanks for leading, and we'll talk to you soon. Thanks, Donna.
Stay safe. Bye-bye. Thanks.